Up here. Yep, here I go. Good evening. Can everybody hear me? Oh, whoop. All right. Whoops. My name is Cheryl Banks. I'm the communications manager at the Heights Libraries, and I'd like to welcome you to tonight's public forum, Bail Reform in Ohio. This is co-sponsored by Ideastream, League of Women Voters, and Case Western Reserve's Laura and Alvin Siegel Lifelong Learning Program. Libraries have long been a bastion of information and the sharing of ideas, so we are thrilled to be partnering once again with the League of Women Voters on this public forum. Tonight's moderator is Nick Castele. Nick reports on politics, government, and a variety of other issues in Northeast Ohio for 90.3 WCPN and WVIZ PBS Ideastream, Cleveland's public radio and public television station. He also files stories nationally for NPR, and he graduated from Northwestern University's Medill School of Journalism. So thank you for being here, and here's Nick Castele.
No, that's fine. Thank you so much for being here. I really appreciate your spending some time with us tonight to talk about bail reform efforts here in Cuyahoga County and around the state of Ohio. As you probably are aware, this has been a big topic of discussion at both the state and county level. I believe a little bit more than a year ago, we had a local bail reform task force that produced a report, a number of recommendations, and Cleveland Municipal Court has changed the way they do pretrial services as a way to address some of these issues with the setting of bail and the detention of people before their trials. So I'm hoping we can get into some of these issues tonight and talk about where we are right now and where we're going to go. So first, let me introduce my panel. Immediately to my left here is Claire Chevrier, Advocacy and Policy Counsel at the ACLU of Ohio. Judge Charles Patton is a Cleveland Municipal Court judge and is also the chair of the Committee on Pretrial Services at Cleveland Municipal Court. And Judge John Russo is finishing up his term as administrative and presiding judge in the Common Pleas Court here in Cuyahoga County. Judge Patton, I wanted to start with you. As I had mentioned, Cleveland is about a year into a new approach to pretrial services, the intention being having fewer people awaiting their trials in jail and more people awaiting their trial out in the community. Can you describe for us how this has changed things at Cleveland Municipal Court in the past year?
Well, thank you, and thank you for inviting us to be part of this. We did not have what we call a pretrial services department in Cleveland 2 years ago. We heard about pretrial service. It was recommended by some think tanks to say Cincinnati, Toledo were running pretrial services, and federal courts were running pretrial services. We went and visited the federal courts operation, Toledo, Cincinnati, and thought we would try this. And pretrial services is what it sounds like. The police arrest somebody and take them to the Sally Port for processing. At the Sally Port, as they walk in to get arrested and arraigned and fingerprinted, there's a representative from pretrial services to greet them, talk to them, ask them what happened. Do you have a job? Where do you live? Do you have someplace to live? Are you on any medication? Those questions to ask somebody to find out what kind of condition they're in. There's a risk assessment tool that will look and see if this person is a risk to the community or not. And the Pretrial Services Department is working on creating the risk assessment tool's answers. So by the time they come to an arraignment in front of a judge, within 24 to 48 hours, we've started some social service intervention if it's needed. And we also have an idea of what type of bond to set for this person, if an electronic monitoring device would be appropriate. And I just got my jail numbers today, with regard to how many people we have in jail for the Municipal Court of Cleveland. And I thought about it. We have a total of 90 people in the Cleveland Municipal Court jail, our 13 judges. 2-3 years ago, the workhouse, Warrensville Heights, on Harvard and Northfield Roads, we've closed that down and moved all of our prisoners down into the county jail. We would have on an average day between 200 and 300 people in jail. So during this year, we have reduced our jail population by more than 50% by utilizing the pretrial services, the adjustments to bail, sitting bail numbers, and getting more people out in the street.
Jump in really quick and ask about that. When you're talking about 90 people from Cleveland Municipal Court who are in jail, who are those defendants? Are they all people who have been charged with misdemeanors, or are they more serious offenses? Where are they in their court process?
These are the people who've been arrested by the Cleveland Police, the University Circle Police, the Cleveland Clinic Police, the Cleveland State Police. There are 17 different police departments working in Cleveland. They make arrests, felonies and misdemeanors. Not everybody who gets stopped by the police gets arrested. They may get a citation and sit on their way. But that's who's sitting in jail. And 2-3 years ago, we had people sleeping on the floors at the workhouse because they were overcrowded. Capacity was normally around 190 people was max at the workhouse. So
and just to be clear for folks, it's called the workhouse because that was its historic name, but you didn't have people in there like hauling bricks around or something like that. That's what people called it in Cleveland.
Well, it was, in the old days, there was a farm, Cooley Farm, and it worked. People would work on the farm during the summertime. People at the workhouse would also go to Cleveland public parks and clean them up. So there were work crews that went out. There were guys that worked on the farm. There were activities, and they cooked. They cooked their meals. They would kill a deer sometimes on wild turkey or whatever. But I grew up less than a mile from the workhouse on Harvard, and so I was familiar with the building.
Right.
And it was called the workhouse because people worked out there.
Well, I want to get back to more about Cleveland Municipal Court's pretrial services, but Judge Russo, I wanted to go to you and ask you to explain, as you said to me right before we started, you're going to be sitting in the arraignment room for a little bit this holiday season. As you are sitting there as a judge, people are being arraigned on a variety of offenses. What goes into your decision making? You've got to set a bond for them. How do you do it?
Well, first of all, thank you for having me and for letting me speak here on behalf of the court. Thank you for coming out today. If I could, before I get to that,
sure.
If I could say to then, just follow up what Judge Patton said so you can conceptualize. So while they're in their room arraigning the individuals who are coming on misdemeanor charges, at the same time, there are felony charges coming, and those are the ones that come to the 34 judges on the common pleas bench. So the municipal court in Cleveland, which about 60% of the cases that make up the felony docket for our common pleas court come from the Cleveland Municipal Court. So you have to see they're doing two things at one time. They take that felony case and bind it over. That's a legal term, but it comes over to us. And so so you should picture both of that. And the judge and their court has done a wonderful job using the PSA in moving their misdemeanors out of the county jail into their pretrial services. So where's this connection that we're trying to make, that I've been trying to make from the common pleas court? And if I can go there, and then I'll go back to your arraignment.
Sure, yeah, that's
question.
fine.
You have to understand there's 13 municipal courts in Cuyahoga County. And so you've heard a little bit about how do you make it all one like it is in Franklin County, and that's a legislative action, not our action. But we are also receiving cases from the Rocky River Municipal Court, Shaker Municipal Court, the Parma Municipal Court. So they're coming from all over to us downtown. So how do we process close to 15 to 17,000 cases that come in on a yearly basis? So that's kind of what happens with us. And what have we tried to do? So as the administrative judge, which again, I'll just be finishing my sixth year as the administrative judge. When I first came in, there was a time frame that averaged about 30 days when someone would be bound over from the municipal court on a felony, and quite possibly that was the average, they would sit in a jail until they were seen and a bond set and sit in the county jail. So we closed that 2 years ago under what we started as a first appearance docket, where all the municipal courts were getting cases to us, and we were evaluating them with a bond and getting them before a judge within 4 days. And they were having a lawyer appointed to represent them if they needed one, and then second, their bond was being reviewed. So we closed that gap for a lot of reasons, and Claire could probably talk about some of those reasons about how it affects someone's life in a matter of 3 days, right? Losing a job, a home, whatever it might be. So we closed the gap to 4 with a lot of help from the municipal courts. And I have to shout out to Laura Black, who's sitting in the back of our room here, because the clerk of courts had to work really hard with us. And so she oversees Naila Bird's office as the chief, and so I know she's here today as well. But so all of that had to work together, close the gap. So now you're saying, what's next? Well, the gap is what? We want to close it to 0 days. We want to be able to, when Judge Patton is sending a felony to us, we want to be there that day in order to set a bond, appoint a lawyer, and then discuss pretrial services. So that's something I'll talk about, not right now, because now I'm going to go to your question.
Sure.
I'll talk about it sometime in the next 45 minutes, because I'll leave you at bay thinking, what is he thinking? So now to answer your question. So when all of those cases come right now on that 4th day, they come by us 2 ways. So someone who comes in on a felony can agree to waive the grand jury. So the grand jury is citizens from Cuyahoga County who view facts and decide if someone should be billed or no billed, indicted or not indicted. That case comes to me or my judge in the arraignment room, as Nick just asked. Sometimes it comes to us by a lawyer and his client waiving the grand jury, and sometimes it comes by the grand jury. When it comes in front of us, at that time, to answer your question, we then have our pretrial service, our bond commissioner, who have interviewed the individual, whether they're in jail. If it happens in jail, it's within 3 days. And if it's someone who's not in jail, when they come in, we have their bond reviewed prior to them coming in, someone who's already made their bond. So what factors are we looking at? We look at, first of all, recidivisms, meaning have they been in trouble before and have they failed to appear in the past? So we're looking at prior cases if they have them. And if they've skipped a bond or they failed to appear or they had to get arrested to come back, did they pick up a new case while they were on bond? What's the charge and nature of the offense? The rule says, do we look at how convinced are we of the facts that this person committed a crime? And then we also look at their, what we call needs base. You know, as the judge said, do they have a place to live? Do they have a drug addiction? Do they have a mental health issue? And we try to assess those to determine a bond that could be set and or pretrial services that could be provided to them.
How quickly are you making all these decisions?
So when they come in, it's under that 4 day. It's called the first appearance docket. That's we've interviewed them before that 4 day. So if they're in the county, so if they're in the county jail, we've interviewed them, we've done our assessment, and we have that recommendation on the 4th day in our first appearance docket.
So, thank you also for describing the efforts, the changes that Common Pleas has been trying to make. I wanted to ask you, looking ahead, I know you won't be the administrative judge next year, but where do you want to see this go? Because I know that the bail task force report that came out, I said a year ago, I think it's more than a year and a half ago, they had recommended things like a centralized pretrial services system that all of the courts could participate in, a centralized booking system, these kinds of, a more centralized way of doing things rather than having this sort of Byzantine system of courts. What do you want to see happen in the near future to move in that direction? So
one thing I'm going to say, Nick, is I've told every time someone says, well, Judge, you're leaving as the administrative judge, and I say, I'm not going anywhere. So I'll say that to all of you. So I'm still a judge, and I'll still be around poking. And so where do I want to see? Two things. You mentioned the bail report. So those of you, there was a commission that I asked to be done and it was written and finalized. It would have been a year in March, and so it's about 18 months now. I'm going to provide a written response to the report. It's in final draft form. I've had some individuals look at my English and make sure my I's are T's are crossed. So that report, probably next week, I'm going to release it in response to what was provided to us as grounds to do here in Cuyahoga County, and some of the measures that everybody's made. That's not our court, but stakeholders. And then what would I like to see? Well, pretrial service, and so you should know it's not just something that happens like this, right? Boom, it doesn't happen like that. So there have been discussions, and I want to say as back as probably the last 9 months. First of all, we had to make sure that there was funding, right? And so that just got approved yesterday in the budget. So we're excited about that. The executive's been on the same page with us, and he's worked with us to make sure that the funding's available. So we're happy about that. The next step is taking over GPS. So the GPS monitoring was being run by an outside agency and the sheriff, and it was being kind of dysfunctional on how it was being handled. We are going to take over that process in the Common Pleas Court. We just finalized that yesterday. We think by January, we are going to be running and monitoring GPS. And then finally, what are the pretrial services, and how, just like Judge Patton said, how can we provide those for all the felons that are being brought to the court and give them opportunities to have mental health services right there and then? Can we give them drug treatment opportunities? Can we get them a Narcan? Can we give them other opportunities while they're still waiting for their charges to move through the criminal justice system, how we might be able to help them? And so those pretrial services are at a place right now where I believe we are looking to use the Cleveland Municipal Court as a pilot project. And this is an agreement with the court and Judge Michelle Early as the administrative presiding judge. We are using their PSA, so that PSA is the Arnold Foundation, and they're going to allow my employees to look at the individual when they come in the very first day. We call it 3D. So they appear in this courtroom on the 3rd floor, and it's the D court, so it's the 3D court. And those felonies would come in, and we would assess them that day and ask the municipal court judge, and the Cleveland Municipal Court judges have agreed to look at the assessment that we are giving them to say, this case, this guy, John Russo, is not even yet a felony in the Common Pleas Court, but we're going to look at the pretrial services that day, and the judges from the municipal court will say, John Russo should be in this type of pretrial service, and then we'll take that person from that day, the very first day. We'll have a lawyer there present, we'll review the bond, obviously, and then apply pretrial services. And then finally, there's a matrix that we're using, and it's a matrix that's been used in 2 other states, at least 3 other states that have used a matrix. What does that mean? It's if you just look at a matrix and you say, the judge gives me a PSA number of 4, and we go down their PSA number, which is the Arnold Foundation, a proven, and run that across to this. This would be the type of pretrial service we would have for this person, and it would be an ankle monitor report twice a month, or whatever it might be. And we're going to be asking, using the matrix, for our municipal court judges to tell the person in front of them, here's your pretrial services, but it's going to be funded by our court.
And just to bust the jargon here too, a PSA, you're referring to a pretrial risk assessment.
That's correct, the Arnold
And
Foundation risk assessment.
Basically a scorecard, for lack of a better term, that examines elements of somebody's past, their job, what's their criminal history. It's supposed to help judges make decisions about what kind of bond to set or what kind of setting this defendant should be awaiting trial in.
I would think Judge Patton would, if he would say this, is they've been using that risk assessment, and then he just said, we've cut our jails by 50%. And we would hope that that's how things would happen with us, using the risk assessment and the matrix.
So Claire, you've been following a lot of this, what's been going on in Cuyahoga County for some time. What's your assessment? How do you rank what judges have been doing?
Sure.
Wait, so I just got to say, Claire's the watchdog.
Yeah.
And she's been great. And she's, they have been, they are on top, emails, calls me, and always has her finger on the pulse. So I say congratulations that as actively as you have been involved. So I thank you too.
Thank you. I
Yeah.
appreciate it. And thank you, everybody, for being here. And thank you so much for inviting me to talk and continue to work in that watchdog capacity. So I do applaud all of the work that has been done in Cleveland Municipal Court and in Cuyahoga Court of Common Pleas, thanks in large part to Judge Russo's administration of it. And that's often the part that's like not added when we do press, because then I followed up by saying, but we have some major concerns. And so, for example, well, to take a step back, in Ohio, we have a two-tiered system of justice in which wealthy individuals who are assigned cash bail as a condition of release get to go home, and they get to go home to their families. And those who don't have deep pockets and can't pay for their cash bail as a condition of release stay in jail. And as Judge Russo explained, said that I might be able to chat about previously, the people who are forced to stay behind bars suffer unimaginable consequences. They're more likely to lose their job, they're more likely to lose their home, they can even lose custody of their children. And even if you think about it in like logistical sense, if you were arrested on your way home today and you were held in jail overnight, would somebody even know to feed your pet or to pick up your child? There are really major concerns. But also, cash bail undermines our entire criminal legal system. And that's because it makes people more likely to be convicted. So in our country, 90% of convictions occur not by the trial by jury that you see on Law and Order, but via plea deal. And under a cash bail system, people feel more coerced into taking those plea deals because of all of what I just explained. If it's possible, if you take a plea deal, you could go home tomorrow, depending on how much time you've already spent in jail, versus trying to fight for acquittal, but that might mean longer time in jail. A lot of people take the option to go home. But we also know that cash bail undermines someone's ability to adequately fight for their acquittal. So people who are held pre-trial, compared with those charged with the exact same offense but who were able to afford to purchase their release, are more likely to be convicted, more likely to be sentenced to jail and prison, and more likely for those jail or prison sentences to be 2 to 3 times longer on average. And that's because it's hard to mount your defense behind bars. Not only is it hard to contact your attorney, it's hard for your attorney to come to you. But an example that a law professor from Akron told me is, if your attorney says like, oh, is there anyone you know who was there who can like back up your alibi? And you say, yeah, my friend Ray Smith. And they say, okay, what's Ray's number? But you're in jail, and you don't have Ray's number memorized, so you can't give it to them. And Ray Smith might be a popular name, so it's hard, or maybe it's Ray O'Malley, or a name that's really common in Cuyahoga County. Then it might be impossible to find Ray. Or so maybe that the defendant will say like, well, no, attorney, like maybe Ray works at this location during these hours. Could you go? And so the attorney might go and be like, Ray? And Ray might be like, I don't know that lady, I'm not responding. But had Ray seen his friend there, he probably would have walked over and felt more comfortable talking to the attorney. So there's a lot of just logistical reasons why it's harder to mount your defense from behind bars. Also, once you ultimately go to court, you're more likely to be in a jumpsuit than in your street clothes. And then at the point of post-conviction, when you're talking about possible sentencing, if you were released the whole time, you get to talk about, I have a job, I drive my kids to school every day, this is how I help my community, I have this place that I'm going to go home to. If you've been held in jail for the last 30 days while you've been waiting for your court hearing or your ultimate sentencing, you're not going to be able to show any of those things. Maybe you will have lost your job, lost your home, and lost custody of your children, and you have no idea what you're going to do when you get out. And so what we see is, even for people with the exact same facts, the exact same charges, the outcomes are worse for people who cannot afford their cash bail. And that means there's a problem with the cash bail system. So now to take a step back and talk more specifically about some concerns that I have with what's going on in Cuyahoga County and Cleveland Municipal Court, more specifically is risk assessments. And risk assessments were a really exciting possibility because it's nice to think that there might be this objective tool that could tell us whether or not somebody is dangerous or not, or more likely to appear or not. But in reality, it's not an objective tool, and there's no such thing as a risk assessment. Some of them are way better than others, and the PSA is one of the better ones. But there's no such thing as an objective risk assessment tool when all of the inputs that it uses to make its decision are based on the underlying biases that exist in policing and the criminal legal system. So for example, what are the factors that different risk assessments use? Well, some really bad ones, and the PSA does not use this, some really bad ones look at, are you from a high crime neighborhood? Well, that is just a direct criminalization of poverty. Some better ones use arrest. Well, we know that people of color are more likely to be arrested for things that they have not done, and they're more likely to be over-policed generally. So arrests really just elevate police decision-making, not somebody's riskiness. So then, the PSA also doesn't look at arrests. But then you look at convictions, which the PSA does use. But we know everything that I just said is true, that some people are more likely to be arrested. And under a cash bail system, there's a lot of coercion that goes into being convicted, whether you're coerced to accept a plea deal or you're unable to successfully mount your case to prove your innocence because you were held behind bars the whole time. And so convictions also isn't an objective measure of whether or not somebody is going to be a threat to public safety or whether or not they're going to appear. There's also other factors like, has someone failed to appear in the past? But a lot of risk assessments are an algorithm. You input yes or no, and you get a number coming out. And there aren't always, and sometimes there are once you get into a judge's chambers, if they provide you the opportunity to speak or to have your attorney speak on your behalf. But often, the algorithm doesn't provide for that kind of qualitative information. If I have a second, this is a true story from when I was practicing in DC, that my client was in the middle of a trial in the afternoon, and a woman came hobbling in a thigh-to-ankle cast on crutches with a hospital bracelet. And she interrupted the trial, which caused havoc, and the judge is saying order, and they're saying hold on, ma'am, what are you doing here? You can't do this. You're interrupting a trial. And she said, I had a hearing at 9 a.m., but I missed it because I slipped on the ice outside the courthouse. And she had slipped on ice outside the courthouse, gotten picked up by an ambulance, and driven to the hospital. She got the thigh-to-ankle cast, crutches, and went straight back to the courthouse. And the judge was nice and stopped the trial and quashed the bench warrant that had been set in her name and set a new hearing date for her. That woman has a failure to appear on her record and would probably show up as a likely risk of failure to appear because of that. And while that is a hyperbolic story that I swear Scout's Honor really did happen in DC Superior Court, there are lots of stories that could happen to any of us. Our bus was late, my kid got sick, or I forgot, or I slept in and I'm not more likely to be dangerous. That just stuff happens in real life. And risk assessments don't necessarily alter for those real life scenarios. And that's why, even though they are, in many cases, a way to get people out of jail quicker, when you look at the data and the racially disparate outcomes of risk assessments, and the fact that most of them that have undergone racial bias studies have found that there are more false positives for people of color than there are for white individuals, that okay, it's a decarcerative practice, but the goal isn't to get white, wealthy people out of jail faster. The goal is to adopt a system that provides justice and would hopefully release more people on their own recognizance than just certain groups of people. So we are generally against risk assessments.
And on their own recognizance means you don't have to pay any money, basically.
Yes,
you get to go, and there's no money involved.
You sign something saying, I promise to show up, and your word is your bond, and you get to go home.
Well, Judge Patton, let me ask you, because Cleveland Municipal Court has gone all in on risk assessments on this Arnold Foundation tool. Do you agree that there can be flaws embedded in what numbers you track and how you grade things?
Yes. I say that so quickly. We've known that there's nothing perfect about this risk assessment. We're trying it out. We're aware of the numbers of young black men in jail. 6% of the population of the state of Ohio, young black men. Almost 50% of the jail population, state of Ohio, young black men. 6% on the street, 50% in jail. We've known that number for years. We've started doing this. There are a number of risk assessment tools. So hopefully we've picked one of the better ones with the Arnold Foundation. And there are some people who wanted no part of the risk assessment tools for a number of reasons. But we had to start somewhere. Hopefully, we've been successful in reducing the number of people who were being detained in jail too long. And Judge Russo was right. 2 days in jail can alter somebody's life. Loss of a job, loss of a spouse, loss of a loved animal, all kind of bad things can happen. Loss of your car. The faster we can move this legal process along and identify who needs to be retained in jail and who can be out on the street, we're hoping to make some improvements there. So yes, I agree. I totally agree that there are some problems. Hopefully we're addressing them. There are some people who do not acknowledge there is a problem. There are some people who want to lock everybody up and throw away the key. We have people in our society like that. And I used to be a city councilman in Cleveland. I have been to community meetings where I was told there are people who need to be in jail. And some mothers told me that about their sons. So we have some problem children, and we've got to deal with them. But we also have some mental health issues that need to be addressed with some additional funding from the state.
Well, when you said that there are judges who will acknowledge that this tool is flawed, like anything is, what do you do then to make up for those flaws, or to make sure that you're not applying it in a way that's biased?
There's no simple answer. I promise you that. It's not a simple answer. Trial and error. Some judges, as they serve on the bench longer, get mellow. And I heard one of the justices of the Supreme Court, Justice Black, talking, and he at one time was in favor of the death penalty, then he was against it after his years on the bench when he was constantly seeing a disproportionate number of poor persons getting electrocuted versus rich people who could afford a high-priced firm to represent them and get out of trouble, shoot somebody on Fifth Avenue, and nothing will happen. So we've got those ingrained problems in this society, and we have to talk about them. And communications, bringing this out to the public, is beautiful because people are talking about it, seeing the issues, saying, how can we make our society better and more fair? Equal justice for everybody. It's not equal justice in this system. I recognize that. We know that, but not, and we also know not everybody knows it. But we've got this risk assessment tool. It's going to be adjusted. We're talking about ways to improve it. We've got some challenges to meet all the needs in the community, the homeless problem, the mental health problem, the education problem, which all contribute to more people being in jail and needing services to help them adjust when they get out of jail. So I'm glad that we're having the conversation. I'm glad the Arnold Foundation is still in touch with us, and they're assessing what they can do to make it better.
Now, Judge Russo, another element of pretrial services that gets a lot of attention are the GPS monitors. A lot of defendants, I don't actually have numbers in front of me here, but a lot of defendants who are out on bail as part of Cleveland's pretrial services program do have GPS monitors. And you talked before about wanting to sort of centralize that system so you can keep track of them all. Why do judges want to use those? What do you think those bring to your system?
And can I add a part of that question?
Sure, go ahead.
Because Judge Russo, you said that you were also going to be taking over the GPS monitoring, and I know that currently the sheriff does it in Cuyahoga County. And while Cleveland Municipal Court does not charge its individuals to pay for their own GPS monitoring pre-trial, my understanding from this year's system assessment is that Cuyahoga, when you're assigned a GPS monitor from Cuyahoga Court of Common Pleas and the sheriff puts it on, you are charged. Are you planning to make it not? Are you planning to not charge individuals for their own GPS monitors under this new system?
Okay. So I have four fingers here because there are four things I want to.
Right.
So I'll go real quick just
Sure.
so you could. So the judge mentions homelessness. So I want to be able to say, yes, it's a concern of ours. because when someone doesn't have a place to live, where do you send them a notice and how do you notice them? So there's two things that we've just implemented on my way out. One is texting. So I have now programmed it within our own system, tested it for the month of October and November, and now we're going to roll it out fully to every defendant accused of a crime that comes before us, that we will text them their notices, regardless if they're homeless or they don't have a place to live or they're bouncing between. And the effectiveness of that is shown across the United States to be a positive one. Second is the texting. We are starting a homeless social worker that's going to work within our court, so that since someone is identified in the jail as being homeless, we have been this is secret, so you don't even know it yet. So you're going to be the first. But I've just got approval from the DRC, the Department of Rehabilitation and Corrections, and they're going to allow us to use some of their beds that they use for individuals who are leaving the jail after serving a sentence that they aren't using. So we've noticed that some beds are empty, and they're going to allow us to put someone who's in a county jail who's homeless into a bed and actually turn that bed for some time while they're in process with us, possibly into some full-time living arrangement with somebody. So we have 2 individuals. That's going to roll out in January. I haven't announced that yet, so you're the first to hear. And now let's go to GPS. Well, let me take one more step, because I agree right here we have a problem, right? So I want to make sure you know I believe that too. And it comes in all forms of charging, of overcharging, of concerns. I hear what Claire and the ACLU is saying, but there's also, what do we owe you with the law? The law says, are they more likely to commit a crime, and are they more likely to appear or not appear? What do we use? It says it. That's what it says in the criminal rule. So what are we going to look at? I'm not saying any of what we use is perfect. The judge said exactly what I would say is this matrix that we're going to use, we're going to use it, we're going to test it, we're going to modify it. And in fact, the judge has provided us 6 months of data back to June up until today that we're looking at and applying our matrix to say how many people would have been released from the county jail and not put in the county jail in these last 6 months, so that we can say, hey, this matrix does work, and it works in a good, favorable way. Or you know what? Maybe it didn't work the way we have it set up, and we need to adjust the matrix so that more people are out of the county jail. So we're doing all that. I agree right here with everybody, but it's not as easy. So here's one example I'd say to you, is if we didn't look at a criminal history, and we have that 18-year-old from west side of Cleveland over by John Marshall who picks up a charge of burglary for breaking in a house, right? And you don't have any criminal history to look at, and you say, well, let's not put a bond and just give this person a personal recognizance. And we say, well, is it wrong to go look at the juvenile record even, right? So do we look at the 5 charges of burglary and breaking and entering in the juvenile court that he had at 15, 16, 17, and now he's 18? So there's an issue. So how do we know that the person's not going to come back when I tell you in 4 years they've been involved with 5 different breaking and enterings or robberies or whatever it might be? So it's a tough one. I don't say there's an easy answer. GPS. So right now, so you're both the question. So GPS would be monitored. Right now the sheriff is doing it, and we have found some inconsistencies. Lots of inconsistencies with the sheriff.
One of them being, I believe, that sometimes there aren't enough, right? Because they're all out in use.
They're out in use, and the monitoring of it. Look, the sheriff's worked very hard with it, but we have come to an agreement that it would be better served if we watch them. Because different people were coming in and watching them and not reporting violations. And then we were finding the person on a domestic violence who's not supposed to be around the alleged victim, and then they're living with the alleged victim, right? And nobody's telling us that there's a violation. So we have agreed to monitor those, put additional staff on them so that we know when we have to notify. And so there's a little bit of a misnomer. So the sheriff originally, I think when Sheriff Bova and I spoke about the GPS, we helped with the first purchase of 300. The court paid for those. And then the county, I think we purchased 150 more, so we're up to, I think, 450. And I think originally the cost was going to be $8 or $8.95, and maybe the cost to the county was a couple dollars. And we indicated that anybody who was declared indigent or unable to afford a lawyer, that those individuals would have their costs waived automatically. So if you came in and you've been deemed to be someone who's unable to afford counsel and you've been appointed a lawyer, that the cost of a GPS, if you had a GPS, was going to be waived. I'm under the understanding that that hasn't happened. And so those are matters that are going to be dealt with, and something that we believe that should have been happening that hasn't been happening. But then it goes down to these judges that Judge Patton talks about. Some who have mellowed in their age, some who come in screaming and yelling and pounding, putting everyone behind bars. We can only tell the judge this is what we think is the best. This is where the law, the law says, and this is where we want to. But if that judge decides not to do it, or if that judge decides, there are some of my judges who want every person on court supervised release, which is a cost for everybody, which not everybody needs to report to someone weekly and provide a urine sample every week. But some judges are using the resources and say, this is what I'm going to do, even though we've said it's not needed for everybody. But that's where the argument is, as Judge Patton said, we can't control every judge. We give them recommendations and ask them to follow those recommendations.
And you're saying, judges are independent elected officials, and to some degree, you can't tell them exactly what to do all the time.
Right. I've always said my job as the administrative judge is I have, 34 judges that I oversee, but I have no ability to tell them what to do. Yes. And it's a delicate walk as the administrative presiding judge.
So I've got a lot of questions here from our audience that I want to get to, and one I think is a good transition, Claire, that I want to put to you, which is what are the state issues on bail reform? For folks who may not be familiar, the Ohio Supreme Court this year issued a number of recommendations that are meant to address this issue at the state level. Claire, could you talk about what you think are the opportunities for changing the system statewide?
Absolutely. So to somewhat clarify, the Supreme Court of Ohio is in charge of creating rules that govern the different practices of state courts across the state. And so there are different types of rules. Some of the rules that the Supreme Court oversees, if they want it, they can make it happen. And some of the more serious rules, the rules of practice and procedure, are rules that actually have the power of law. And those have a way more tricky procedure by which they're also run through the General Assembly, which allows them to have this power of law. And the Supreme Court of Ohio is currently looking into two different rules that pertain to bail, and one is each of the different types of rules I just described. So it's about to get a little confusing. One is bond schedules. So the Supreme Court of Ohio is trying to make it so that bond schedules across different counties are the same.
And a bond schedule, if you could explain that really quickly.
Sure. A bond schedule is if court is not in session and somebody's arrested, let's say on a Friday night in an area where there's not going to be court until Monday. The sheriff's office or sometimes the court might have a bond schedule where it's depending on what the charge is or what the offense level is. Somebody might automatically say, okay, this offense or this level, you have to pay this amount. And then they have the opportunity to bond themselves out before they go to court. We have some major concerns about this because that's a wealth-based system of detention, because if you're wealthy, then you get to go home that weekend, and if you can't afford the random amount that has taken into consideration zero of your personal ability to pay, then you stay in jail. So one of the things that the Supreme Court is trying to do is make it at least uniform, because in places like Cuyahoga County, there's different bail schedules in different municipalities, and so it's somewhat like justice by geography, that if you're arrested on this side of the street, maybe you get a $500 bond, but if you're arrested on this side of the street, maybe you get a $1,000 bond. And the Supreme Court is trying to fix that, and so their rule of superintendents, which is the kind of rule the Supreme Court can just wiggle their nose and create, is to make it so that all counties that have multiple municipal courts have to make it all the same and either adopt the bond schedule that the Supreme Court is suggesting or adopt their own, but they got to make it uniform. We kind of feel like, I've been calling it low-hanging unconstitutional fruit. It makes sense to clean up the system, but if what you're cleaning up is doubling down on an unconstitutional wealth-based system, I don't think that cleanup process is that helpful. The other big rule that's going on right now is edits or proposed amendments to Criminal Rule 46. And that's a big deal because Criminal Rule 46 governs the bail setting practices for all state courts in Ohio. And the process by which Criminal Rule 46, which is one of those criminal rules of rules of practice and procedure which do have the power of law or the weight of law, is way more complicated. The Supreme Court cannot wiggle its nose and change this. The way that it works is the Supreme Court opens up for comment period, asks public to tell them what they want to see changed in the proposed language. They then sometimes open it up for comment again. Then they send it to the General Assembly. The General Assembly has the option to also open it up for public comment. The General Assembly updates it, sends it back to the court. The court then sends it back to the General Assembly, and if the General Assembly doesn't vote to reject it, then it becomes law in July of whatever year this is taking place. In November, the Supreme Court of Ohio opened up this rule for public comment. We submitted a very robust comment that had 50 different signatories that put their name agreeing with us, and hundreds of people had subsequently wrote to the Supreme Court saying that they too agreed with our comments. And then, surprise, this morning, they've decided to open it up for a second comment period that's going to close on January 2nd. So this was an interesting Christmas present for us. And so we are going to submit another comment because our thoughts on Criminal Rule 46 currently is that they've done a lot of changes that make it sound good, but that practice would not be changed based on these rules. So, for example, the Supreme Court has added language like, all conditions of release have to be the least restrictive. But it doesn't require a judge to make a finding on the record of like, why is it least restrictive? Why is it necessary? Why, based on what's in the record, is this? It doesn't require any of those steps. So it's basically not making judges show their work. Similarly, the language says that if a judge chooses to assign cash bail as a condition, the cash bail has to be the least costly. But again, there's no requirements that a judge undergo an ability to pay determination. So if a judge is not asking what somebody's finances and what are their different financial obligations, then they're not able to figure out what amount of money is least costly, what amount is going to be an incentive to return to court versus what amount of money is going to lead to detention for the remainder of their case. And so while there's been a bunch of changes that sound good, there really aren't the procedural safeguards that make us confident that there will be any change. And so that brings us to our hope is that the legislature is going to choose to act. Even if the Supreme Court created way more robust changes, that's not the place where the details are hashed out. The Ohio Revised Code is. And right now, we really do have this bipartisan, nonpartisan, call it what you want. Everybody who's paying attention seems to want some form of bail reform because they realize it's not fair to have to stay in jail because you can't afford bail, because poverty is not a crime. But the way that our system treats it as a crime is wrong to many of us who are paying attention. And so our hope is that the legislature will realize that there's an opportunity here, that the ACLU would be behind it, the Buckeye Institute would be behind it, all the different people who they either choose to care about or not care about the thoughts of seem to be working together to push for this, except for maybe the bail bonds agencies.
And the prosecutor.
And some prosecutor
prosecutors.
offices, and there are different PD offices that agree or disagree with certain aspects of this. But generally, what we hear is, yeah, absolutely, it makes sense to send people home if they're not a risk and they're not going to cause harm.
Well, Judge Russo, so you were a part of this task force.
Yes.
Do you think that these proposed changes would actually change the reality in local courts around Ohio?
Yeah, so two things. So I sat on the task force that they're speaking of. I would say this, imagine 800 judges, okay? So that's what you're talking, 800 judges in the state of Ohio. And so how are you gonna, all judges elected, right? And so how do you move that? How do you move that to where we need to be? And so you have to start somewhere. And so this whole idea of cultivating the farm, planting the seed and watering it, I mean, you have to start somewhere. And so while I agree that maybe there have been other task reports that I've sat on, the criminal death penalty one that we issued 53 recommendations that have sat on a shelf and gathered dust for the last 3 years, other than one of those recommendations. I'm hoping this doesn't, right? And I see there were legislators who sat on our committee too, who clearly understand what the issues are. So I think there's a good opportunity to push it to the legislature because those individuals sat through all of the discussions that we had. And so while I do understand them pushing out to January, I think it's a positive. It's a push because I think what you provided to the Supreme Court is being taken under consideration to modify and and give a little more teeth to some of the things that were originally placed in. There are some pushback from judges, right? You're getting pushback from the judicial, some judges in the state. We do have the legislature, so I think it's the right time. I do believe it's an issue that's has much interest, and I think Ohio, there are a lot of states that are cutting edge. I mean, we just jump over to New Jersey, and we jump over to some states right by us who have taken it that next step to the legislature, changed everything, and said, guess what, judges, you got to do this, right? And when you say that, I got to do it. I have to follow the law. And so that's not where it is right now, but it's close to it, and we do need to have that continual push. Do we have a spokesperson in the legislature who's our advocate? I think there's some who are bordering, do I step out, right? I got to get elected in 2 years, every 2 years. Am I willing to step out to my constituents and say, I stand for this change for these reasons, and risk maybe not being reelected, or maybe risk being the face of moving the state to somewhere we need to move to? And Judge, you were going to say
Patton,
something.
yeah, you wanted to throw something in about the Supreme Court's ideas.
You're correct. Online, you can look up and print off the report and recommendations. And the committee did a great job. And if I could just go through a couple of these. Require a validated risk assessment tools, number one. Require presence of counsel for all defendants at pretrial.
And that would be at their very first appearance before a judge, have a defense attorney there. Some people are going before a judge, having their bond set, and they don't have a defense attorney.
That's right, and the recommendation is they should have their attorneys present at that point in time. Tailor pretrial services and there are differences in urban areas and rural areas, so they're recommending it be tailored. Consider alternatives to detention. Leverage technology, sending text messages about court dates so people won't forget about them and miss them. Educate and train judges. That's number 8. I saw that and said, brilliant, just truly brilliant. And there's a requirement for data collection. They want to analyze and see what's working, what's not working, train the judges and tell them, we have found that this works, you should do this. It will help you. And this is why, and debate it, talk about it, but make some movement toward correcting a broken system.
Well, let me ask you, I think this is a good chance to throw in another audience question here. When you are forming a pretrial services department in Cleveland, that means you've got a contract with a nonprofit, Oriana House, that does the check-ins. This question is, does bail reform save money or cost money? If you've got to spend money on a pretrial services program, and if you want to do it in all 88 counties and all the little municipal courts within them, is it going to be an expense, or do you think that this is actually a savings in the end?
We are spending between $100 and $150 per night per defendant in jail. We are spending less than $10 per defendant every night they're on the street with the GPS and with pretrial services costs. Less than $10. Is that a savings? There are 2 ways to answer that. Yes and hell yes.
And I can provide some numbers for that. So on any given day in Ohio, there's up to around 12,000 people in a jail pre-trial, so legally innocent individuals. And that comes to around $266 million a year spent on detaining legally innocent individuals. And that's exactly the numbers that were just stated. On average across Ohio, because the amounts vary depending on where you are, it's about $65 a day to hold somebody, and in Cuyahoga, it's a lot more. It's over $100 according to the system assessment. And so we're actually it's easy to point to New Jersey and other jurisdictions and say that this is how much money they saved. And the numbers that I just said, the $266 million, that was created by the Legislative Services Commission when the last bail bill was in the legislature. That's who came up with that number. They looked at it by crunching DRC numbers of how many people and how much on average jail beds cost per night. But we at the ACLU of Ohio wanted to dig a lot deeper because we didn't want to just point to what was happening, cost savings that occurred elsewhere. And also we didn't really know how much pretrial services would cost in places that were developing it totally by themselves or who had never had maybe a probation office where a pretrial office could sit. And so we're actually currently in the process of looking into, of doing a large-scale fiscal impact analysis because we also recognize that sometimes the places where the cost savings exist are not the same places that would have to take on the expense of changes. And we want to be realistic about who would save money and who would be out money so that we can provide real information, hopefully to legislators when they eventually bring forward a bail bill. We want to provide not just any information, but Ohio-specific information based on our data, based on our courts. And we've been incredibly thankful to all of the different judges who have provided us the data on which we're relying to create this report.
I wanted to ask you really quickly, Claire. We were talking before about proposed changes to Criminal Rule 46 and doing this through the sort of, I don't know, the administrative side that the Supreme Court has the power to change. I understand there's also been discussion of possibly a state constitutional amendment that could address these issues. Do you think that is an avenue that people should consider?
It's definitely an avenue. I understand all the arguments for not putting anything else in the Ohio Constitution. It's wild, but what we
got
have
casinos
here,
in there. We got all kinds of things in there already.
We've got this Criminal Rule 46 timeline in there.
Yeah.
But at this point, there's people being held in jail who are innocent, who are no threat to society, and it is bankrupting our communities of money that could be better spent elsewhere, and it's harming lives, it's harming communities, and ultimately it's making everybody less safe because people who are held in jail longer have higher recidivism rates, which just translates to more likely to commit crimes later or to be accused of committing crimes later. Everything about this current system makes us less safe, isn't smart, and harms individuals. There's even a bunch of studies that say that there's no difference between return rates for unsecured bonds versus secured bonds. So secured bonds mean you have to pay up front before you leave. Unsecured bond means you sign something, say, I will have to pay if I don't show up, but you don't have to put money up front first. The studies show that it causes people to return to court at the same rate. There's just no point in what we're doing. So even for people who don't feel warm and fuzzy about ballot initiatives generally because they think the Ohio Constitution is too full, I hear you, but at this point, I think that people should pay attention to absolutely any possible avenue for reform because what we're dealing with is too harmful.
So, one thing we haven't talked about yet that I've got a question here that speaks to is the role that prosecutors play in this process. And I know we don't have any prosecutors up here to speak for themselves, but Judge Patton, I did want to ask you this question that came from the audience, which is, when you overcharge, don't you ensure a high bail? If somebody comes in having lots of charges piled up, you haven't yet had a discussion yet about whether there's evidence to substantiate these charges, but you've got to make a decision on bail based on the charges before you. Do you think that's a factor in high bonds?
And the risk assessment tool comes into play here because I met with some federal judges, and one of the judges said, Charles, you've got to change the way you think about some things. Gun case. Gentleman goes out to the airport, businessman, has his briefcase, goes through the metal detector, and there's guns in there. So alarm bells go off because of shootings in airports, terrorists, everybody's terrified. So, and we get these cases in Cleveland Municipal Court, believe it or not, at the airport. And I would always set high bonds for people, I said, stupid enough to carry a gun to the airport. But somebody who's a diamond salesman carries a gun. Doctors sometimes carry cash, carry guns. Forget about the gun in the briefcase, and it's innocent. So if the risk assessment comes back, no priors, no criminal record, job, stable person, his score is going to be a 1. But the gun spec will make it go up to he's going to have a high bond just because it's a gun at an airport. But we don't do that now under the risk assessment. So that's the kind of training that we have to change in our mindset to make that adjustment as to what's going on here in reality with the gun at the airport, but what's possibly a person, no criminal intent, no criminal history. He should walk out of court that day and go home.
Now, I imagine that may not address if
Overcharging, I did, yeah.
or a history if someone has been charged with lots of offenses in the past, or has failures to appear for whatever reason. I mean, those things might show up in a risk assessment.
Yes, they will. They will. And so that score will go up from a 1 to a 4 to a 6. And so and it makes it easier for the judge to figure out quickly whether release somebody with no terms, let's go home, stay out of trouble, forfeit the gun, or no, it's going to be a high bond based on past history. And the overcharging, I don't really get to even see the overcharging at first because I look at the risk assessment tool first. But the charges are there, they'll come up, and why they're overcharged, judges are very often, the majority of them used to be prosecutors. So they know the overcharging game and why the police bring those charges in with the recommendations to overcharge.
I wasn't a prosecutor. I was a criminal defense lawyer.
But even criminal defense lawyers know that.
Yeah.
So, they figure it out real quick. So we understand what's going on with the charging mechanism from the prosecutor's office.
Well,
Sure, I would
if you
say
want to
if
address
any
that,
of you
I've got
have a
another
little,
question for
just
you.
one second here is constitutional amendment. If any of you have time and feel like you could really effectuate change in the state, it would be a centralized database system for the criminal justice system in the state of Ohio. If you want to get to the answers that I wanted to get to on the death penalty task force, on who was indicted and how it was racially imperfect in the state, if you want to get to overcharging and is it really happening, overcharging in order to get a plea on a case, if you want to get information about who's sitting in, we do not have a centralized data collection for the criminal cases in the state of Ohio. I think a lot of people would say, please don't do that, I'm nervous about it. And I'd say we need it in the state of Ohio so that we can right system what we have in a lot of ways that we talk about. And as Claire said, she's knocking on my door, and I think I saw my reply from my IT department. We're trying to get her some information because she wants to look at this economic factor. And I said, yes, I'm going to give it to you. And
I didn't want to out you as that, but yes,
yes,
it's been very
you
helpful.
could out me because we're almost there. So we didn't say no, but I think it's tomorrow. He said he's going to get it to you, so we're hoping. But yes, we need that. So I say that in not attacking prosecutors and not attacking any certain stakeholder. But I think, my Supreme Court might be upset if they heard I said that, or maybe some of them. My colleagues might be upset with me. But I think it needs to be done in order to have that equal comparison with Coshocton, Cuyahoga County, and Dayton, so that we all know what should be consistent and what is happening in the state of Ohio.
And we agree about data collection generally. Both Cleveland Municipal Court and Cuyahoga Court of Common Pleas do have race demographics, but many courts in Ohio don't even track that. There's no way to tell whether or not judges are acting in racially biased ways, having racially disparate outcomes for people, because they choose not to write down the race or ethnicity of individuals, so there's no way to fact check.
Well, I wanted to ask also, and I want to be mindful of time too. I'm not sure how much time we've got left here.
One says 5 to 8, one
yeah.
says 5 after 8.
All right. Well, we'll split the difference. But I do want to ask, and okay, and maybe Judge Patton, I'll put it to you first. Clara talked before in looking at things in Criminal Rule 46, trying to have more procedural guardrails in place when someone is being arraigned. I remember sitting in the arraignment room to watch the process a couple years ago in 2015, before you began using the risk assessment and the pretrial services program to the degree that you're using it now. What struck me about it is that it was very fast. You had defendants came in, there was a public defender standing at the front, one lawyer for everybody in the room. This was often their first time meeting that lawyer. People come up, you talk about their case very briefly, you get some basic information, you set a bond, you move on. if you're trying to add more procedural guardrails into this process, where you're really looking more in depth at someone's case, maybe you have a more adversarial process where someone's got to justify why they're seeking a high bond if they're a prosecutor, for instance. At the same time, you're trying to process all of your cases in a speedy and fair way. How do you balance that? Do you think that you can slow down the arraignment process and still do your business?
Well, there are, bail is a requirement out of the Constitution. A fair and reasonable bail, I think, is the term they use. So this goes back to the beginning of the country. Now, some things have happened along the way, and across the country, there are differences regionally as to what's fair and what's not fair. Everybody's supposed to be processed from the time of arrest to either 24 hours or 48 hours and have had a chance to be in front of a judge with an attorney to address those issues. It's not happening. Years ago, it was months sometimes, and people just sat in jail. So we're addressing these issues, and you saw a quick process because of the technology. But the additional collection of data will only help us. So I agree also with regard to a centralized system of data collection for the entire state. How can it be better? Having these discussions, looking at the recommendations that came out, getting citizen input, talking to your state reps, your state senators. The money we save hopefully will help out on the back end of what's going on here. All the money we're not using to house people in jail, we can spend on social services, mental health services, educational opportunities. There are ways to redirect that money, and we're talking big dollar amounts. So your question was about the speed in the process in 3D or the arraignment room. It can be speeded up. There's probably an IBM machine that can do this now, but it wouldn't have that human touch. But we're trying to utilize all the technology we can in our court to make it more fair and faster and more just.
Well, Claire, could you describe what to you, in your mind, would be the ideal way that an arraignment goes? Could you just walk us through it? What does it look like?
Sure. I also want to take a step back because Cuyahoga County does it a little bit strangely. Arraignment is not necessarily the first appearance. Usually the first appearance occurs in municipal court. Then if it's a felony, they'll get bound over to the Cuyahoga Court of Common Pleas. Then there might be a first appearance. It's not until the indictment come back that the indictments come back that the arraignment takes place. So in other jurisdictions, sometimes the first time you see a judge is arraignment, but that's not the case here. But what we want is a presumption of release, that everybody automatically gets released unless. And the unless is a big part because people come at me all the time asking, like, why do I want murderers to be free? And that's not the case because you got to listen to the unless. We want there to be a presumption of release. Unless a judge or a prosecutor asks because there's something in the facts of the case or something in the person's history that makes them nervous that they would be a public safety risk or a risk to a specific persons, or organization, or that they might willfully flee. If there's something that triggers that fear in either the judge or the prosecutor, then we think they can request a hearing. The automatic default shouldn't be a costly hearing at which counsel's usually denied, and people have to wait in jail for that to occur if they can't pay for their initial bond. It could be automatic release, and then the exception is one of these hearings. And our hope would be that there would be so many fewer hearings that we would be able to provide counsel at those hearings. And then at those hearings, if a judge found by clear and convincing evidence that this person is a safety threat to a specific person, or organization, or likely to willfully flee, then the judge should be able to consider conditions. And we want the judges to have at their disposal a ton of possible conditions. And we want them to be able to look at what, based on these specific facts, what makes it, and this kind of goes to the matrix, but this would be without a risk assessment tool, then what should they get? Because the answer shouldn't be, all right, if we're going to let you out, you automatically get a GPS. Because what we know is, and currently in Cuyahoga County, and I'm excited that that's changing, it costs $8 a day that you have to pay pre-trial for your GPS monitor. And that comes to $56 a week. And so you don't have to be indigent to not be able to pay over $200 a month for your own confinement via this that some people call e-carceration method.
But I'll jump in. But while it's charged, you don't have to sit in the county. If it's being charged, you're still released with the GPS, and the cost may accrue. And at a later time, you could ask for it to be waived because of indigency or because you're unable to pay it. So you don't sit in the jail and not get a GPS because you can't pay for it. So you should. So just so you know that they're not sitting, hey, can you pay? No, I can't. Well, then you can't get out. We'll put a GPS on, and if the cost is charging, it's charging to an account. They still are out on their GPS just for that purpose. But
yeah, and that I wasn't trying to suggest
no,
otherwise.
I didn't want you to. I wasn't suggesting you were suggesting, but I just want to make sure you knew that.
Just that it's a coercive practice to every day realize that you're paying for your own confinement, and for many people, GPS isn't necessary. And so we want judges to have at their disposal lots of different conditions, and then we want cash bail to really be limited to the person who has a $10 million jet who can go to a country where they have a home that doesn't have an extradition treaty. That's a great person for cash bail. Pretty much nobody else should get that. And I want to go back to what I said about the factors being willful flight. Right now we look at failure to appear. And judges sometimes, not all judges, but some will say like, well, this person is homeless and they don't have an address, so we're not going to be able to send notice, so they're now a failure to appear risk. And sometimes the failure to appear is really a different form of criminalizing poverty. What we think, what we want the message to be shifted to is this person going to willfully flee? Does this person have the means to hightail out of here and avoid justice? That would be a great person to consider high cash bail or maybe preventative.
So just so the matrix is that. So I didn't want to get really into the matrix, but I'll say it real quickly. So again, if you just say 9 boxes, right? Just say there's not, and the matrix. If you fall in the matrix here, you're just released. No cash, no bail, nothing. If you're down in the middle section, well, then it's maybe you're reporting twice a week, and you need to have provide a urine once every month. And then over here, it's GPS. This very last block over in this corner is who we then send to a hearing. So you have an automatic hearing on your bond the next day with the judge. So that's exactly what we're trying to create with the matrix, is only at the very far end of the matrix, is there an automatic hearing and a lawyer is given to you. Actually, the public defender is worked into the cost to be there on the very first day. So we're going to have a public defender there to represent you the very first day. But then even going to the hearing, that's where we're looking at it as well. So I just wanted to add that.
And that will be a huge improvement on the current system that we have. And it's really exciting, and I think it will have a decarcerative effect. So fewer people will be in cages in Cuyahoga County, which is, I think, something that everybody has been working towards. But there are still ways to make it better. And using a risk assessment tool that's turned into a matrix is something that gives us pause, because we know that there's racially disparate outcomes. So we are so thrilled about all of the different things that Judge Russo has done and that Cleveland Municipal Court has done on their own and in connection with Cuyahoga County Court of Pleas. But it's also our job to continue to be vigilant. There was a while ago where a lot of pre-trial folks were really excited about risk assessments, and then we saw the data that came out of them, and it turns out they're terrifying. And so we just need to make sure that even while we're supporting reforms, that we're also being critical and making sure that we're still reviewing to make sure that we're working towards better progress.
So one last question I want to ask here before we go, Judge Russo, is at the same time that all these discussions of bail reform are happening, judges are talking about building a new justice center, possibly. And where is it going to go? Is it going to be, along the Opportunity Corridor next to the police headquarters? Will it be somewhere across town? Do you think that there is a real risk that this effort around bail reform is going to get lost or stalled in this conversation of, do we build an entirely new building for the jail and the judges and everything else?
And so Judge Patton and I just talked about that before we started here. We just had presentations given to both the judges in the Common Pleas Court, Court of Appeals, Domestic Relations, Probate Court, and then also the Municipal Court this week on Monday. The programmers who are looking at the options for a new jail, renovated jail, a new justice center, and renovated justice center. So we had those presentations. I think we both agreed there were more questions than answers that were provided at those meetings. And so to answer your question, you know, there's two other things kind of floating out here. We're talking about mental health crisis centers, so you'll hear that terminology being pushed out right now. And then we hear about what we might call centralized booking. So those two things are being talked about and bantered. Those are very important topics that we don't have time to talk about here, but a crisis center is, hey, we pick up John Russo who's having a mental health issue. Maybe I'm yelling and screaming on the street. I'm in my underwear. And what would happen when that normally would come to a police is they would pick me up, arrest me, and bring me to the county jail. And then they'd charge me with something, right? And then you see where that's wrong. And so what really should be happening is that person should be brought to a mental health crisis center, which is nowhere connected to a jail or a police station, and the medical facility would be there to help them and not criminalize their action. So we're talking about that in Cuyahoga County. Then we're talking about how do we centralize these pretrial services? How do I take the same money that the judge is using in municipal court and the common police court and put all our resources together into what we would call a pretrial service that would provide all opportunities for housing and education and mental health and drug treatment for everyone in Cuyahoga County who's bringing an accused who now has been accused of a crime into the system. How do we help them? So those two things are being discussed along with a new jail and a new justice center. We have been told emphatically that we have two jails. One's called Jail 1 and Jail 2. So if you look at the building, Jail 1 was built first. It's closest to Lakeside. Jail 2 is closest to St. Clair. Do I have those right? Yeah. Yes, I do. And they have told us as of Monday that Jail 1 cannot be repaired. It cannot be renovated. It needs to be torn down. Clearly ineffective and inefficient. Jail 2 with modifications, but lots of money, could be renovated. I believe the focus is going to be the jails right now, and possibly either what we believe possibly a knocking down of those jails and moving them off-site. And that brings a whole discussion on transporting inmates to the jails, to hearings and things of that sort, or can you do it by video? Those are opportunities you can do now. So I think what's come back to us is that those two jails probably need the biggest amount of work, and the cost of running those two jails, when they showed us those numbers, are numbers that could pay for a $500 million loan in order to pay for two new jails or a new jail complex. And that jail complex is not up. So it's ineffective when you build 7 stories as opposed to these 5 pods, a female pod, a juvenile pod, or whatever it might be. So I think that's, it looks like that's the concept that maybe come out of this. Then the second concept is, do we rebuild a justice center, and where should that be, and what would it look like? If both options are chosen, I see a real strong push that the justice center, if it's going to be rebuilt, would be downtown somewhere. I don't see that being pushed outside of downtown. But I could see it being somewhere where we just stay on the same property. So if you just imagine if jails were knocked down, you have all this space to rebuild a justice center and maybe implode the current one. Those are all the options they've presented to us. None of those have been finalized, or they've been put out for discussion. The executive has said through his programmers that decision hopefully will be made by May of 2020. So it's not far away, because those numbers are being crunched and pushed and designs are being put in front of people right now. But to answer your question, yes, we should be talking about centralized booking, mental health services on site of a jail, mental crisis centers off site, all in this concept of what might be built for Cuyahoga County.
I have a lot of follow-up questions to that, but in respect to people's time, I want to say thank you very much to our panel for spending your time with us today. Thank you to everyone here for being a part of this conversation, and thank you to your questions. To those I couldn't get to, I apologize, but I appreciate your engagement with this topic, and I hope the conversation can continue in the future too. Thank you very much.